Ladies and gentlemen of the Louisiana legislature, I consider it an honor and am grateful to be provided an opportunity to address the legislature on behalf of a group of fellow diligent public servants, the judges and staff of the judiciary, who share the same concern of the public servants and their employees who serve in the legislative branch of government. Our common concern is to work together to best serve the citizens of our state. This is the first time a Chief Justice has had the opportunity to appear before the legislature since 2018 due to scheduling and COVID issues. I will try not to take up all of the time that we left on the table over those years. Roughly 45 years ago, I sat in the back of this chamber in this very corner. Needless to say, 45 years ago, Representative Francis Thompson was here. And I got to know him then. Representative, you may recall, back at that time, long hair was fashionable. And I see you've held on to yours, and I am left longing for hair. I had the invaluable learning experience all those years ago to serve as a legislative assistant to a senator, Harvey Pelche Jr., and to a representative some years later, Representative Billy Tozan, who went on to serve in Congress. Both served in the legislature in the 1970s, apparently, as I look around, before many of you were born. Note, I did not say, except for my friend Francis Thompson. Note, I did not say he is an old friend, please. My colleagues on the Supreme Court and I know very well the sacrifices each of you make, and also that your families make for you to serve. While sitting in the back of this chamber all those years ago, I allowed myself just a moment to contemplate the possibility of one day addressing legislative colleagues from this very podium. Like most legislative assistants, I presume I contemplated the possibility of serving in the legislature one day. But as I got older, I got wiser, and noted that y'all have paid about the same as members were paid back all those years ago. So I refocused my goal to serve the public and became a full-time teacher of law and ethics at Harvard. That's Harvard on the Bayou, Nichols State University in Thibodeau. I asked those people from my district to go ahead and do that. Thank you very much. I didn't get paid much more being a teacher, though. And since then, I've served in various judicial capacities, and last year became the 26th Chief Justice. Like you in the legislature, we don't serve for the financial rewards, but rather the opportunity to serve that attract all of us to public service. Mr. Speaker, I learned how gratifying it is to be of service to others, growing up working in my father's service station. I am joined today by my colleagues on the Supreme Court. By custom, we do things by seniority, but custom must yield occasionally to old-time ethics and etiquette and good manners. Our newest colleague is Justice Piper Griffin of New Orleans. Jay McCallum is here, a former legislator. Justice Will Crane of Bogalusa and Madisonville worked as a legislative assistant to the late 60 Rayburn for many years. Jimmy Genovese of St. Landry Parish and Opelousas is with us. Scott Creighton of Shreveport and Webster Parish, and Jeff Hughes of Walker. All of the justices came up through what I refer to as the first responders of the judiciary, all having served as district judges, trial court judges, addressing citizens' issues face to face and person to person, case by case. Together, we work hard resolving the many cases before us as a group, each of us spoke on each and every case. The most important case we decide, the most important case that we ever decide, is a case immediately before us, because that's what the litigants think it is, the most important case. We have a new clerk of court for the Supreme Court, Veronica Odene-Poplanis, who was once a staff member for the legislature, and if the last name sounds familiar, she is the daughter of former legislator Representative Ken Odene. I believe Veronica is in the balcony. Acknowledging the potential for being too basic, the judiciary, of course, is a separate and co-equal branch of government which performs core constitutional functions essential to our system of democracy and our constitutional system of checks and balances. The judiciary provides a forum for citizens to resolve disagreements, for adjudicating criminal cases, for ensuring constitutional rights are protected, and for addressing issues involving rights related to life, liberty, and property. On average, over the last 5 years, more than 1.2 million filings occurred every year in Louisiana's courts on average. That means if today is an average day, there will be 3,287 filings for judges to address. Almost as many bills as y'all introduce this session, right? I firmly believe that a judge is a public servant who serves by being dedicated to the principles of justice, fairness, independence, and impartiality, applying the law as it is written by the legislature and signed into law by the government. Based on our civil code heritage, the Louisiana Civil Code teaches legislation is the primary source of law. When the law is clear and unambiguous, its application does not lead to absurd consequences. The law will be applied as written by the legislature. This court does not legislate from the bench. Please allow me to speak for a moment about finances. The judicial budget is what I refer to as a microcosm of the state budget, meaning the judicial budget has, like the state budget, constitutionally mandated expenditures that cannot be cut, mandated expenditures that are statutorily dedicated funds that cannot be spent on anything but the dedicated purpose, interagency transfers, and federal grants, all of which significantly limit the ability of the judiciary, just like the state, to respond to budgetary challenges in funding the core functions of the judiciary. For fiscal year 2022, the judicial budget, including the programs that I'll address momentarily, is approximately 0.5% of the entire state budget of Louisiana. Last year, the legislature restored some of the cuts from 5 years ago, and for that we're grateful. But as you know, inflation has risen exponentially. The current fiscal year judicial budget is only $4 million above the budget from July 1st, 2015, even though the mandated expenses such as healthcare and lasers have increased by $6 million, which does not account for general inflation in other areas of the budget. If the inflation factor that the Division of Administration uses each year was applied to the judicial budget from 6 years ago, we would get $4 million more than what we are requesting in the bill that we submitted. So from my perspective, we are saving the state $4 million. Thank you very much. As valuable and indispensable as your employees to your everyday work, our employees and staff are equally as valuable and indispensable. We have some of them with us today. We need to recognize that value, particularly due to the inflation figures that we've just seen lodged from last year. Judicial employees have not seen a pay raise in years. In our system of democracy, the institutional legitimacy of the judiciary depends on its independence. The Declaration of Independence referenced the lack of judicial independence as a grievance against the king. Let's not repeat that issue. Granted, independence must be tempered with responsibility, mutual respect, and comity. Independence is contingent, in part, on proper funding. Our system of democracy, in order to survive and flourish, requires that the public believe our courts have the necessary tools to render fair and impartial decisions. If we do not maintain our system of justice, then there will be no justice. The legislature, year before last, provided $7 million of CARES Act funds that were one-time funds spent on one-time expenses related to the virus, as required by federal law. As good stewards of these funds, the judiciary spent a portion of the funds on one-time expenses primarily for technology so the judiciary could continue to function to provide access to our system of justice during the continuing pandemic. And this proved absolutely indispensable the last 2 years when hurricanes ravaged the coast of Louisiana not once, twice. And then tropical storms and other hurricanes came. But without those funds, it would have been very difficult for the judiciary to continue doing its work as it does. I will come back to these funds a little bit later. I am proud to say, although courthouses had to shutter due to public health issues or hurricane devastation, the courts remained open virtually, and judges implemented and learned new technology to ensure our system of justice remained viable. Jurisdictions innovated and utilized auditoriums and gymnasiums and even tents to ensure public safety while conducting court proceedings. The Supreme Court established a technology commission, which has initiated a plan to bring every jurisdiction in our state to a more consistent level of technology across our state, which is especially important in our rural areas. Technology is saving time and cost to litigants. While we took the next step in making sure that our judges had the technology that they needed to conduct court proceedings remotely, that was just the beginning. And we're currently working on a proposal to seek funding for additional technological advancements and enhancements which would ensure that all judges have the tools they need to run a court in the 21st century and also address cyber security challenges that are becoming more and more prevalent, unfortunately. We are also evaluating legislation known as Clean Slate, and we look forward to our continued discussions with Representative Boyce Duplessis and others regarding this important legislation. The Supreme Court's Technology Commission has been ably chaired by a judge now known, particularly in this particular chamber, as a spouse of Representative Lori Slagle. We are proud to share that her husband received a national honor bestowed by the United States Supreme Court for his efforts in using and promoting technology in the Louisiana court system. Representative Slagle, would you be willing to point out the individual elsewhere known as Judge Scott Slagle? Are y'all standing because of the award you got, because we married? He is the first Louisiana judge to receive the Chief Justice William Rehnquist Award. As an aside, I believe he received this award in part because I advised U.S. Supreme Court Chief Justice John Roberts that Judge Slagle was not just a technology expert, but also a regular guy. And he's a regular guy because along with Senators Allen and Smith and Fazee, and I believe Luna, Representative Gaines and Weiser and myself, the Slagle rides very fast motorcycles, but always within the speed limit. Congratulations, sir. Along with us also today is Judge Yvette Alexander, who serves on the Baton Rouge City Court and was sworn in as president of the American Judges Association last year. This association is the largest independent organization of judges from all jurisdictions and levels of court throughout the United States and Canada. Judge Alexander, I believe, is either the fifth or sixth Louisiana judge to lead this international organization. Judge Alexander, please. Judge Alexander, you don't have a spouse in this group to stimulate that standing ovation, right? These two judges are two examples of how Louisiana judges are leaders nationally. In addition to the core functions, such as resolving disputes in administrative justice, allow me in summary fashion to touch on what our citizens in this body receive in return for their investment in the judicial body. I refer to this as an investment because there is an economic and societal return. Please note that Louisiana is in the distinct minority of states in the country, but the Supreme Court administers all four of these programs. Drug and specialty courts include drug treatment courts, family preservation courts, DWI courts, mental health courts, veterans courts, and reentry courts. All of these courts require additional work and training for which the judges do not receive additional compensation, but they receive the immense satisfaction of serving others, much like each of you. These courts teach professional responsibility and accountability and favor rehabilitation over incarceration, reduce recidivism, and save the state money in corrections, mental health, and health care, while also, most importantly, while also saving souls and saving families. I can tell you about statistics, but there are brochures and a packet that each of you have on your chairs that tell you all about these. But let me tell you about remarkable transformations. If you attend a drug court graduation and read the testimonials of graduates that are in your packet, just remarkable how people can change and become productive members of society. One veteran court participant said this: "The benefits of attending veterans courts are immeasurable. If I had to pick out the greatest things, they would have to be the installation of core values I had as a member of the armed forces, values such as integrity, service, and excellence. Veteran court mandated that I return to a lifestyle that was honorable." The legislature's investment also allows the judiciary to administer the court-appointed special advocates program, in which ordinary citizens who are community volunteers advocate for among the most vulnerable in our state, children who have been abused and neglected. In 2021, 1,610 CASA volunteers, who are your neighbors, who are your friends, who are your constituents, and in many cases, who are your family members, served 3,490 children, and they dedicated 53,447 volunteer hours, equaling over $1.5 million in savings for the state. Most importantly, 1,968 of these children were able to leave foster care to safe, permanent homes, saving the state approximately $2,400 per month per child, amounting again to millions of dollars in savings. I'll tell you a brief story without going into further statistics. There was a young lady who had just graduated from college and starting her career. career was really taking off. She's doing phenomenally well. She's driving down a roadway from one appointment to another, and she saw on the side of the road a small child. Next to the child was a grocery bag. Senator Connie, it was paper. There's a bill coming, y'all get it. When you finally get it, just go ahead and laugh out loud. She believed that the paper bag contained all of this child's early belongings. And as she drove past the child, their eyes met for a moment. But she looked away because, after all, she was busy. She had places to go. She had things to do. And as she drove away, she happened to look in the rearview mirror, and she could see the child get smaller and smaller and smaller as she drove down the highway. And just before the child was out of sight, she read in the rearview mirror, objects in the mirror are explosive when they appear. And she knew that was etched in the mirror since she bought the vehicle, but she could not help but read at that time. And she turned around and went back to the child, and the child spoke first, and she pulled up, and the child said, "Are you God? Because my parents left me here. They told me God would take care of me." I said, "No, child, I'm not God." And she could see the disappointment in the child's face. She said, "I'm a child of God." And the child brightened up and said, "You know, when you turned around, I knew if you wasn't God, you had to have been related." PASA volunteers are godlike to these children. They represent what is wonderful about our state, people who volunteer to give back and serve others, just like all of us in this room here. The court also manages the Family in Need of Services, or FINS program, that serves to effectively address self-destructive behaviors by a child and conduct by other family members which contribute to the child's harm and which warrant court intervention so that the appropriate services to remedy the family's dysfunction can be secured to preserve the family. I've talked to a number of legislators who are so concerned about families in the state. The Supreme Court is helping keep families together. Domestic violence is still too far prevalent in Louisiana and throughout the nation. It is critical to address the protection of victims in our state by making resources widely available. The Supreme Court administers the Louisiana Protective Order Registry, a statewide repository of court orders of protection for victims of domestic violence and dating violence and stalking and sexual assault. The registry operates on an on-call service available 24 hours a day, 7 days a week, 365 days a year. It won a national award from the FBI some years ago for its competence in addressing domestic violence. These programs are not the judiciary's core function. And if we did not manage these programs, our budget would go down exponentially. The irony, though, of our budget is that we build these programs at the request of legislators and the legislature, and we make these programs viable and available throughout the state. However, we're facing deficit spending the last few years. And using some savings, we have accumulated over 30 years of saving money, a little bit here, a little bit there. All the while, we are helping rehabilitate those with substance abuse and mental health issues. We are serving abused and neglected children. We are assisting to preserve families and to protect those subjected to domestic violence. The judiciary has to fund its core functions. So when we are here late in the session, begging and pleading for additional funds, we are pleading for the constant children, we're pleading for those in the drug courts, we're pleading for those facing domestic violence, and we're pleading for families to stay together. As the last North Louisiana two-term governor said, I need your help. Won't you help me, please? Well, it's not me that needs your help. It's the people that are listening, the judiciary. I believe our judiciary should be what I refer to as FIT, an acronym that reflects concepts of frugality, integrity, and transparency. Indeed, among judges, and my colleagues will probably laugh out loud when I say this, I am known as tight with state funds. I prefer the term frugal. Occasionally, Justin Wilson had this to say. There was a child that was a student, a Cajun boy, and he was assigned a word to write a story about. And the word he couldn't understand, so he went home and showed it to his Cajun mama. And she looked at it and she said, well, how do you call this word is what you call frugal? And he said, okay, what that means? She said, frugal, that means to save. So he put pen to paper and he wrote a story. Once upon a time, there was this beautiful princess riding through a swamp. And all of a sudden, she fell in this giant hole and could not extricate herself from that hole. So she began yelling, frugal me, frugal me. And a handsome prince came by and jumped down in the hole and he frugal her. And they lived happily ever after. Remember, it's he who laughs last thinks slowest. As soon as y'all get that, go ahead and laugh right out loud. Taxpayers live happily ever after when government is frugal. As previously indicated, in 2020, the legislature allocated to the judiciary $7 million CARES Act money, which was described then as the quote coin of the realm. However, after months of court staff meetings, the judiciary determined that the restrictions imposed by the CARES Act funds by the federal government limited severely what the judiciary could do with these funds and still be frugal. We contacted our colleagues in the House and Senate leadership and worked with the Division Administration and the Governor's Office and returned $5 million of CARES Act money, which was desperately needed at that time by local governments throughout the state and members district. In a meeting before Senate Finance, after approval by appropriations in the House, we completed the transfer of $5 million, for which the judiciary received one half of the allocated funds and an IOU for the balance, secured by trust and goodwill and good faith. It was described by Chairman Weimer as a rare trifecta, a win-win-win, where one branch returns funds to another branch that then reallocated the funds that were desperately needed. I'm proud of the judiciary for initiating this effort and grateful that very grateful last year that the IOU was satisfied. Just remember when we come before you that we did bring some money back at one time. But when we have opportunities like that to work together, our citizens benefit the most. We also save money. Working with my colleagues and our staff, we canceled a long-time lease and brought employees back into the Supreme Court building at 400 Wall Street, saving the state $250,000 a year. Please allow me for just a moment or two to wrap up and share just a couple of initiatives. The judiciary has developed a program known as Judges in the Classroom and Students in the Courtroom. We have partnerships with the Bessie Board and many others. We're meeting with the superintendents of schools recently. What the judiciary is doing, and we urge you to join us, is getting out in the communities to teach young people about how all citizens are created equal before the law, consequences of inappropriate behavior, making good choices, personal responsibility, while also teaching civics, which unfortunately they need to know to be good citizens. Despite the pandemic waxing and waning last year and a major hurricane last year, almost 10,000 students were visited and positively impacted in courtrooms and classrooms throughout the state. I have reached out to a former teacher, senators, who I suggest is still a teacher at heart and president of the Senate, partnering with us. And we hope we can do that. Justice Creighton, colleague, as a district judge, proactively developed a program that teaches young people about the consequences of certain behavior in an effort to convince them that he did not wish to see them in his professional capacity as a judge. He lectured over 20,000 students in gyms and auditoriums, which always included their parents attending. A remarkable accomplishment. I can tell you story after story after story, but I need to move on. A few judges are present, all the many judges who were involved in this program. Let me introduce them very quickly. Judges Randy Bethencourt from Terrebonne Parish, Wendell Manning from Monroe, who is also the chair of the Louisiana Commission on Civic Education. Corella Stewart of Shreveport, Jason DeGay of Terrebonne, Dawn Amago, Washington and St. County, and Lee Faulkner and Shannon Vivas Mobon, Jefferson. If any legislator is interested in partnering with us in these teaching endeavors, please let us know. We'll be glad to work with you. On another topic, I do not have to remind you that the legislature recently addressed reapportionment in a special session. I am positive, after talking to many of you, that you continue to suffer with what I refer to as reapportionment fatigue, which manifests itself in eyes being crossed due to staring at maps and body aches from being beat up and beat down. Obviously, the Supreme Court districts, as currently configured, need modification because of population shifts. However, in their adjudicative functions, justices are not elected to represent people, but rather to apply principles essential to a properly functioning system of justice: impartiality, independence, the rule of law, while representing the ideals that all are created equal before the law, and all who appear must be treated with dignity and respect. As such, perfect population proportionality of judicial districts is not currently legally required. I believe that the districts can and should reflect the historical boundaries that have long existed so as to maintain communities of like interest, and the court should reflect the rich geographical diversity of our state. I do not believe it appropriate for a separate branch of government to opine on what is a task constitutionally assigned to the legislature, but I believe individual justices have a right to confer with legislators. Benjamin Franklin said about democracy, it is the wearer of the shoe who knows where it pinches. And just like each of you knows your district, each of the justices knows the district that they serve. Besides reflecting the community of interest in the current makeup of the judicial districts and not excessively dividing parishes, the court as a whole should provide opportunities to elect those who reflect the rich diversity of our great state, because the Supreme Court acts as a single entity, with each justice casting one vote. Reflecting our state's rich diversity will foster respect for our system of justice, which impacts all of our citizens. Louisiana's system of court costs and fees is an immensely significant issue that needs attention. Speaker Pro Tem McGee heads the Louisiana Commission on Justice System Funding, which is working vigorously to unravel and improve this funding system that federal courts have ruled in 2 cases that are not final have flaws. We cannot afford to fund our judicial system strictly on the backs of people in poverty. Additionally, for far too long, our state has shifted the cost of our state court system to local government, and has done so with fees, fines, and costs to keep the system afloat. In conjunction with the Commission on Justice System Funding, an analysis was performed last year with the assistance of judges statewide by the Supreme Court staff and is posted on the Supreme Court website. The funding of our judicial system should not be contingent on whether or not a court is in an impoverished area of our state. The system of funding is antiquated and does not ensure justice or equality statewide. Let us work together to rectify this inefficient and antiquated system. On another matter, I have been in discussions with judges, legislators, and other judicial stakeholders regarding how to ensure that the judiciary is efficient, effective, and reflects our rich diversity. Adding and eliminating judicial positions are legislative functions, but functions that the judiciary justifiably has great interest in. No doubt, in recognition of our system of checks and balances, our constitutional forefathers and foremothers wisely required 2/3 vote of each chamber to change the number of judges in any judicial district. It is important to remember that judges must remain independent to apply the rule of law without fear of reprisal when a judge makes a decision fully supported by the law, but which may prove unpopular. In 2006, right after Hurricane Katrina, and again in 2011, the legislature asked the Supreme Court to study and provide information and recommendations on the appropriate number of judgeships. Twice, the judiciary responded and submitted what is now known as the Lentini Report, and later the Act 143 Report, which contained several recommendations, including developing a permanent process for determining the appropriate number of judgeships, including reducing judges when necessary, preferably by attrition. These reports remain accessible to the public and include the recommendation that a work point formula was outdated and invalid and needed to be revised. At this time, based on population shifts and the latest filing data, and because the legislature and the judiciary have a joint interest in this matter, I suggest the legislature and the judiciary establish a joint task force. This task force would not reinvent the wheel, but would instead revisit the previous reports and recommendations, obtain a viable work point analysis, and take action to make the judiciary more efficient and effective. The only way this can be done is if all stakeholders in the judicial system have a seat at the table together. Please know that the justices are disappointed, as many in these two bodies, regarding the state of some lawyer advertising, believing some of it is unprofessional. That disappointment is not new, and it was reflected in changes to the rules regarding lawyer advertising some years ago. However, the ink was not dry on the order signed by the court when we were sued. The First Amendment in our state constitution both reflect that freedom of speech is protected, and the United States Supreme Court has already ruled that lawyer advertising is protected by the First Amendment, as is other forms of advertising. Federal courts are very reluctant to enforce limitations on free speech. The justices pledge to continue to work with the legislature on this challenging issue, and the court has already done quite a bit and enacted some rules to address these issues. Please keep a judicial seat open at the table when these matters are discussed. On one last topic, it is prudent, wise, and necessary to properly fund public defenders to ensure that those who are presumed innocent until proven guilty will be properly represented. Astute prosecutors know that public defenders are an essential component to our system of justice. I commend the legislature for considering this issue. I know you have looked at it the last few years. It is a challenging issue, but funding indigent defense is critical to our system of justice. In conclusion, We thank you for your dedicated service to your district and to our state. The judiciary and the legislature have enjoyed a close working relationship that ultimately benefits our citizens. The citizens of Louisiana are still addressing hurricanes that came the year before last and last year. We're exiting a pandemic, hopefully, and we're witnesses to a tragic war that is unfolding as we speak. But history teaches that the citizens of Louisiana have always responded to challenges with perseverance, resolve, and tenacity. Let us work collaboratively, my friends, to serve our citizens well. On a personal note, I want to thank you for inviting me to address the legislature 45 years after thinking one day I may do so. And Representative Big John Ewing, I look forward to hoopla. And Representative Thompson, I'm glad you're still with us. Thank you all so very much.